session hosting the ICC Moot Court Competition 2015 English version. Please be seated.
That's better. Counsel for the prosecution and the legal representative of victims, I welcome as well the courtroom staff and the security officers who diligently assist us in all our work. I'd also greet those in the public gallery, the participants in the ICC Moot Court competition attending this hearing, and those outside the court who are following us this morning via the internet in this Moot Court competition. I would now turn to the court officer and ask that he calls the case, please.
Thank you. We are sitting in an appeals session regarding the situation in Astafor, ICC Moot Court Competition 2015 English edition.
On behalf of the Chamber, I would now ask the parties and participants in this hearing to introduce themselves, beginning with counsel for the government. But before you start, counsel, I'd like to remind the parties and participants to speak slowly and to pause before responding to any question in order to allow all participants to follow closely. Could I ask you, counsel for the government, to present the members of your team?
Distinguished members of the court, good morning. I'm Amrita Shivprasad, representing the government of Branos in the present matter. This is my co-counsel, Arushi Nargis, and my other co-counsel, Sanjana Rao.
Thank you very much. I now turn to the prosecution team. Likewise, could I ask you, counsel, to present the members of your team?
Mr. President, Your Honours, my name is Natalia Manskova, and I am counsel for the Office of the Prosecutor in this interlocutory appeal of the Pretrial Chamber 6's decision in the situation in Astafor. I'm assisted by my co-counsel, Melissa Leeworthy, today.
Thank you. I now turn to the legal representative of victims. Likewise, could I ask you, please, to present the members of your team?
Good morning, Mr. President. Your Excellencies, my name is Annabelle Teo, and I appear on behalf of the victims. With me is my co-counsel, Mr. Samuel Yap. Thank you.
The team of the registry is represented today by Court Officer Wilfred Ndunga and Mrs. Iona Moraru and Ms. Teresa Lumbama from the Grotius Centre for International Legal Studies. Finally, I'd like to introduce the bench. To my right is Philip Ambach, and to my left, Savina Savides. I'm Judge Howard Morrison and will be presiding in this hearing. The Chamber will now proceed consecutively with the four issues shaping the subject matter of today's hearing, but being mindful of the public nature of the hearing, I would ask the court officer to please read the agenda established by the Appeals Chamber.
Thank you, Mr. President. This case arises out of allegations of war crimes committed in the territory of the state of Astafor by the Cyber War Unit of the Branos Armed Forces. The state of Astafor, population of 1.8 million, and Branos, population of 2 million, formed the federal state of Branafor until the state underwent a negotiated dissolution known as the Velvet Divorce in June 2005. Both resulting states were admitted into the United Nations in November of that year. Although it is contiguous with Branos and separated from Astafor by a body of water, the region known as Pantos had been deemed a part of Astafor by the prior federal government of Branafor, whose capital was Volontos, the current capital of Astafor. On 15 September 2014, the Pretrial Chamber 1 authorized the Office of the Prosecutor to launch an investigation into war crimes committed in the territory of Pantos from April 20th to 24th, 2014. 2. determined that the appointment of a single representative for the victims is appropriate in this case. The appeals chamber seeks submissions of all parties and participants on the following issues. A, whether Astafor is competent to make an Article 12.3 declaration triggering the jurisdiction of the court over war crimes committed in Pantos, despite its lack of effective control over the territory of Pantos at the time of submission of the declaration. B, whether the court has jurisdiction under the objective territorial principle over crimes committed by a non-party state, in this case Branos, via cyberspace that have an effect in a state, Astafor, that has lodged an Article 12.3 declaration. C, whether the widespread disruption of communications and electricity during a revolt against the government of Astafor via distributed denial of service attack constitutes a war crime. And D, whether there must be two different victims' legal teams and a separate victims' legal representatives, in this case because one portion of the victims supported secession and the other favored remaining part of Astafor.
Thank you, Court Officer. I now give the floor to the Government's Counsel to present its case and to discuss the 4 issues on the agenda of this hearing.
Distinguished members of the court, this matter has arisen as a result of a declaration by a non-party state, Astafor, alleging the distributed denial of service attack to be a war crime committed by another non-party state, Branos. In this context, there are 4 issues which I shall address. First, Astafor cannot make an Article 12, Paragraph 3 declaration as it lacks effective control over the region of Pantos. Second, the objective territorial principle enshrined in Article 12, Paragraph 2, Clause A does not apply in the present matter. 3, the DDO's attack does not constitute a war crime. Even if one of the above issues stand before this court, then the court will not have jurisdiction on this situation. And the 4th issue is that the 2 victim teams should have separate legal representation. To begin with my first issue, Your Honors, that Astafor cannot make an Article 12, Paragraph 3 declaration as it lacks effective control over the region of Pantos. This clause allows for a non-party state to make a declaration before this court if it has territorial jurisdiction over that region. A prerequisite of territorial jurisdiction is state sovereignty. State sovereignty is a legally acquired title and the continuous exercise of effective control as laid down in the Island of Palma's case at page 839. The pretrial chamber in paragraph 15 has held the commencement of the attack to be the date to decide this effective control. Your Honor, the effective control must be decided on the critical date of the dispute. On the day of the commencement of the attack, there was no territorial dispute regarding the region of Pantos. It arose only when the military attack ended and the state of Branos signed an agreement with the Pantos Liberation Army. This dispute was crystallized when Astafor made a declaration before the court. In the case of legal status of Eastern Greenland, the International Court of Justice has held critical date is the day the state claims sovereignty over a region, and therefore the court should decide that the critical date of the dispute is the date of the declaration. On this day, Your Honors, the effective control did not lie with the state of Astafor. As defined in the Island of Palma's case, effective control is the uncontested administration of land and its resident population to the exclusion of other states. It is evidenced by the peaceful and continuous possession of that territory. As also stated by the Office of the Prosecutor in the situation in Egypt, effective control is the obedience of the bulk of the population. In the present matter, the plebiscite, the protest against its non-recognition, and the military attack clearly indicate that the bulk of the population's obedience did not lie with the Astafurian government, and therefore effective control does not exist on the date of the declaration. By way of this, I sense a question.
Yes, Council, one quick question here before we're getting into the question of the declaration. Do I understand you correctly that the fact that when the attack started, we do not really have this effective control problem yet is, in your submission, irrelevant?
Your Honor, it is relevant to the matter as the effective control was being lost by the commencement of the attack. But the material date to decide the territorial jurisdiction is the date of declaration. And on that day, it is clear that the effective control did not exist with the Astafurian government.
Would that not lead to me as an attacker state to always make sure that I totally gain control over the territory that I attack so that the attacked state can never lodge a 12-3 declaration? Would that not be a consequence of your argument? Thank you.
Your Honor, in case of non-international armed conflict, it is the sovereignty of a single state alone. But in the present matter, it involves two states, and therefore it is required to see that by making a declaration before this court, the sovereignty of another state is not violated, and hence effective control must be looked into in this respect in case of an international armed conflict. If your honors have no further questions, I would like to move on to my second submission.
One quick one. Please come back to the question of international armed conflict at some point, because I would have a question there, but I would imagine that this is anyways part of your submission. Thank you very much, Council.
I would answer that question of yours in my third submission, Your Honor. Moving on to my second submission, that the objective territorial principle enshrined in Article 12, Paragraph 2, Clause A, does not apply to the present matter. This clause clearly uses the word conduct in question, as defined by Antonio Cassisi in his treatise on international criminal law. It means an act or an omission, and not the consequence of the act. In the present matter, Paragraph 9 of the fact sheet clearly states that the effects alone were felt in the region of Pantos. Therefore, the conduct in question did not occur on its territory. Therefore, by way of this, the objective territorial principle enshrined under Article 12, Paragraph 2, Clause A, will not apply to the present matter. Your Honors, if the effects doctrine were to be read into the objective territorial principle laid down in this clause, the amendment for the same could not be passed at the 7th session of Assembly of State Parties in November 2008. If the court would interpret effects doctrine to be included, then it's in violation of the Vienna Convention on the Law of Treaties. Astafur, being a party to the Vienna Convention on the Law of Treaties, as given in paragraph 3 of the fact sheet, by making this declaration before the court, has imposed obligations on a non-party state, Branos, violating Article 34 of the Vienna Convention on the Law of Treaties. If your honors have no further question, I would yes, Your Honor?
One question here, Council. Do I get you right that you're saying that the word occurred in Article 12.2a refers to where sort of the crime was originated, sent off, so to speak? If you could just elucidate me in the context of what we're looking at here, why is it in your submission relevant for us as the court to look at where somebody hit the send button as opposed to where the crime sort of took its effect? And how can, for instance, we not assume that the effect principle is international customary law, which by virtue of the statute would be part of what we could consider? Thank you.
Your Honor, Article 34, Paragraph 4 of the Vienna Convention on Law of Treaties states that if the specific intention of the parties is to interpret in a certain meaning, then it should be done so. By including the words conduct in question alone, the objective territorial principle enshrined in this article suggests that the state parties referred only to the conduct and not the effects doctrine. Therefore, in view of this interpretation, the objective territorial principle will not apply in the present matter, as the effects alone were felt in the region of Pantos.
Sorry that I insist on this, but is it your submission that even when I look at something like a cybercrime, which arguably is different from me launching a bomb or shooting in terms of, so to say, traditional armed conflict, that the definition of conduct would need to be defined specifically by the court at some point?
Your Honor, the conduct in a cybercrime, also like bombing or firing a gun, requires a button to be pressed, which clearly suggests conduct does originate from a certain point. And therefore, the place where the conduct of this cyber attack happened, that state would have the requisite jurisdiction. And the objective territorial principle can be applied if that state comes before the court. In case of cybercrimes as well, there is an originating place of conduct, and that state will have jurisdiction. And therefore, it can be interpreted that the effects by applying effects it can be interpreted that the effects doctrine should not be applied in the present matter, as there is a state that has jurisdiction to decide this case. If your honors have no further question, I would like to move on to my third submission, that the DDoS attack does not constitute a war crime. Article 51, paragraph 1, if I may rephrase myself, your honors, Article 53, paragraph 1 of the statute requires for a reasonable basis to proceed, there must be sufficient information to prove the subject matter jurisdiction. I submit that in the present matter, there is a lack of sufficient information. And even if the court deems sufficient information is present, then it does not fulfill the subject matter jurisdiction in the present matter. In the case of prosecutor versus, in the situation in Kenya, the pretrial chamber has given instruction to the office of the prosecutor on the 18th of February 2010 that NGO reports that are indirect evidences do not constitute sufficient information, and there should be more additional information provided to prove subject matter jurisdiction. In the present matter, there is only one piece of an NGO report alleging this subject matter jurisdiction before the court. The credibility of the report itself is in question, as it was done in a matter of 5 days, and the sources and methodology of compilation are not clearly stated. Further, your honors, in the situation in Korea, the situation was rejected by the office of the prosecutor as the specific elements of the war crime were not fulfilled. This is a clear suggestion that even at this stage, there is a requirement of proving the contextual elements as well as the specific elements of the war crime. In the present matter, the contextual element of a war crime required is an international armed conflict. As defined by Common Article 2 of the Geneva Conventions, an international armed conflict requires 2 high contracting parties. Your honors, neither the DDoS attack nor the military attack can be attributed to the state of Branos. Therefore, the international armed conflict is not present in this case. Your honors, it is a technical impossibility to attribute a cyber attack to a specific state, as can be seen in the cases of Estonia and Georgia. In the year 2007, in Estonia, a cybercrime alleged to have been committed by the state of Russia. In that case, certain individuals came forth to seek responsibility of the attack, and even then, it could not be attributed to them. Similar circumstances happened in the case of Georgia in the year 2008. All of this clearly suggests It is a technical impossibility to attribute a cyber attack. In the present case, the IRW report in paragraph 10 states that the cyber signature of the cyber unit of the Branos state was present on the DDoS attack. However, as previously stated, the credibility of the report itself is not sure, and it does not constitute sufficient information before the court to prove this attribution. Further, to attribute a military attack to another state, the overall control test laid down in the Tadich appeals judgment at paragraph 131 must be applied. The overall control test lays down that arming and funding of a military or paramilitary group is not sufficient to attribute an attack to another state. They must be planning, supervising, and training. There is a lack of planning, supervising, and training in the present case. The state of Branos only armed and funded but the Panthers Liberation Army, as given in paragraph 9 of the fact sheet. This clearly suggests that neither the DDoS attack nor the military attack were committed by the state of Branos, and therefore the contextual requirement of the international armed conflict is not fulfilled. If your honors have no further question, I would like to move on to my fourth submission. The two victim teams should have separate legal representation. A substantially distinct interest. Your honors.
One point I wanted to interject. I do not know whether that is part of your submissions or whether that would be rather part of a possible reply on the question of the war crimes in discussion. If one were to assume that we're looking into war crimes, but I presume that that would be reserved for whatever prosecution is going to present. Is that right? Thank you very much. Then please continue.
Thank you, Your Honor. The fourth submission is that the two victim teams should have separate legal representation. Substantially distinct interests is a basis for separate legal representation as held in the case of Prosecutor versus Banda and Gerbo. It has been held in the case it is natural for victims to have distinct interests. It is substantial in nature when it relates to their right to justice. Identification, prosecution, and punishment of those who victimize them is one such right, as held in the case of Prosecutor versus Katanga and Gujjalo. Your Honors, in the present matter, a certain part of the victims partly blame the attack on Astafur, which clearly suggests there might be a perpetrator, as also accepted by the prosecutor's submissions at paragraph 34 in their written submission. This clearly suggests that there is a substantially distinct interest, and because of the possibility of the presence of perpetrators in Astafur, there is a substantially distinct interest, and separate legal representation should be mandated. Even if your honors deem this only to be a political alignment, in the case of Prosecutor versus Ruto, it was held political alignment is a substantially distinct interest which should mandate separate legal representation. Your honors, in view of this, I pray before the court to mandate separate legal representation. If your honors, yes, your honor.
One quick question here. If I understand, we're looking at victims of crimes, right? I think it is not in dispute that there are different crimes, it's just one crime setting, and the victim group of this crime is, in terms of their victimhood, rather homogeneous, isn't it?
If you could.
It is the same sort of a homogeneous group that is subjected to a certain set of crimes.
Yes, Your Honor.
Now, the fact that they have different affiliations does not actually have a bearing on the fact that the victimhood is of the same quality. Would that not lead us to believe that a single counsel would be sufficient here? If you could just maybe have 2 words on this. Thank you.
Your Honor, I would like to answer your question by 2 points. First, being in the case of Prosecutor versus Ruto, when the registry looked into political alignment of certain victims to the Orange Democratic Movement, they said if there were the presence of victims who did support this movement, then separate legal representation would have to be mandated. In the present case, Your Honors, there is a certain part of the victim who does believe that they should secede from Astafur and join the state of Branos, and believe the perpetrators are from Astafur. Your Honors, to answer your question that having a common legal representation will still put forth the views of all these victims. Your Honors, as these victims have separate views, a common legal representation cannot make contradicting views regarding where the perpetrator may exist, and it would lead to presentation of each victim as a witness, which would cause delay in the proceedings. And in view of this, separate legal representation should be mandated. If Your Honors have no further question, then I would like to conclude my submissions. I pray before this court to not authorize an investigation in the situation in Astafur. It was an honor arguing before this court. I shall rest my case.
Thank you very much. I now turn to the prosecution to present its submissions on the same 4 issues under discussion. Thank you.
Mr. President, Your Honors, fellow counsel, my name is Natalia Manskova, and I'm counsel for the Office of the Prosecutor in this interlocutory appeal of the pretrial Chamber 6's decision in the situation in Astafur. Your Honors, the situation here is simple. There is ample evidence of atrocities being committed on the territory of Pantos between the 20th and the 24th of April 2014. It is the job of the Office of the Prosecutor to investigate these atrocities and to bring those responsible to justice. At this point in time, we're merely asking Your Honors to allow us to do our job in investigating this situation. We are not issuing an arrest warrant, we're not confirming charges, we merely want to find more information. Thus, we would ask this court to confirm the pretrial Chamber 6's decision in the situation in Astafur pertaining to Article 81 and 82 of the Rome Statute, since the decision of the pretrial Chamber 6 was not affected by a material error. To that effect, I will be making 4 submissions for you today. Firstly, I will submit that Astafur is competent to make an Article 12.3 declaration over its territory in Pantos. Secondly, I will submit that the objective territorial principle is applicable in this instance, and that Article 12.2a should include the word crime instead of conduct. Thirdly, that there is reasonable basis to proceed with an investigation into war crimes that have been committed on the territory of Pantos. And finally, that a single victim's legal representative is appropriate for the best representation of victims' views and in the interests of efficiency of this court. I will now take Your Honors to my first submission, that is, that Astafur is competent to make an Article 12.3 declaration. And here I will be making 2 submissions, and you'll be seeing a common thread of UN recognition guiding you in making a determination on this point. The first limb of my argument is that Astafur is a state encompassing Pantos, and that is the first criteria under Article 12.3 of the Rome Statute. And the second criteria of Article 12.3 is that the entity making such a declaration has the full powers to do so under Article 7 of the Vienna Convention of the Law of the Treaties, and this too has been fulfilled by Astafur. So with regard to my first submission, Pantos has been part of Astafur since the dissolution of Branafur in 2005, and this was recognized by the UN in November of the same year. at paragraph 2 of the facts. And in this instance, we see a strong presumption of continuity of states. States under international law do not easily fall apart, and we see this widely in state practice. And this presumption of continuity cannot be rebutted by a mere one day of following the cyber attacks. Therefore, Astafa continues to exercise sovereignty over that area, and thus is competent to make such a 12.3 declaration. My second point...
One moment. Do you argue that UN recognition is conclusive?
Your Honour, we're arguing that the court should err on the side of caution in determining delineating state borders. This is not the aim of this court, and in this instance there is clear UN practice, and therefore practice of states who form part of the UN showing their recognition of this state. Of course, Your Honours are free to determine the statehood issue on any other factors you wish, but we suggest that the UN criteria should be used in this instance, particularly in the past practice of the court in relation to states such as Palestine, where it was admitted allowed to make an Article 12.3 declaration only after the UN had changed its status. So I will now turn to the effective control test. The effective control test has been a part of international law since the Tinoco claims arbitration, and this test was elucidated by the Office of the Prosecutor in the Egypt decision that my learned colleagues have raised. And in that decision, it was stated that de jure control is the primary way in which we determine effective control, and de facto is merely an additional test. Dr. Morsi in that decision had essentially no control over any of the territory of Egypt, and indeed a new government had been recognized by the UN in that instance. In this instance, we don't see such a situation. We see that the authorities of Astafa continue to be the governing authority of the state, and no such overturn of government of the entire state, which it remains to be so, has emerged. And even if we choose to step away from that interpretation and make a determination on the control over a state's territory, it is submitted that there is no need to have control over the entirety of the territory in the entirety of the time. There has never been a requirement of such control, and we see this also from past practice of the state. For instance, in the Dominic Ongwen arrest warrant decision, paragraph 45, it was evident that the LRA had control over pockets of the territory of Uganda that was exercised in abductions, for instance. And in the Antaganda confirmation of charges decision at paragraph 14 to 18, it was evident that the UPC had control over portions of the DSC. And indeed, in the Ivory Coast also, there had been loss of control of the Ituri region, and nevertheless, it is possible to have Laurent Gbagbo on trial before this court. And therefore, we don't see control over the entirety of the territory as a determinative factor here. I will now move on to my second submission, that the objective territorial principle should be applied by Your Honours in this instance.
Counsel, one moment. I'm sorry.
Yes, Your Honour.
You lost me at the end of your first argument. Just so I understand, is it your submission that effective control was irrelevant for the question of Article 12.3 to be applicable, or partial control over the territory? I just fail to understand what the crux of your point was. If you could just give me a brief one there. Thank you.
Yes, Your Honour. The submission is that there is no necessity to exercise effective control over the entirety of the area of the state of Astafa, including the region of Pantos, and then the control that was exercised at the time is sufficient to fulfill the effective control test.
And when you say at the time, what time are you directly referring to? And I'm now bringing you, I think, towards the argument that we've heard before. What time is, in your consideration, the crucial time that we as the court would have to look at in order to determine this? Thank you.
Well, Your Honour, my learned colleagues in their memorials have made submissions on both the date of the beginning of the attack and the date of the declaration of the Article 12.3. And of course, we note that there is a certain loss of control of the area of Pantos in relation to the date of the declaration on the 25th of April. And we submit that even on that date, the Astafarian authorities did have the sufficient control to fulfill the effective control test. Thus, I will take Your Honours to the argument that the objective territorial principle should be applied in this instance. The submissions will be the following. Firstly, that this court has used the word crime and conduct interchangeably in its past jurisprudence, and thus there is no necessity to depart from that practice now. And secondly, that the Vienna Convention on the Law of Treaties also supports this interpretation of the Rome Statute. We have found 7 decisions of this court stating that the word conduct and crime are used interchangeably. That is, in fact, how the court has dealt with this issue, although, of course, it has not specifically been discussed. And if I may make an explicit reference to the case of Prosecutor and al-Bashir arrest warrant decision of the 4th of March 2009, it was stated that the crimes at paragraph 36 must meet one of the 2 alternative criteria in Article 12.3, and further in Article 38, the court says that the conduct, including unlawful attacks against civilians, murder, extermination, rape, etc. And so the word conduct is made in reference to specific crimes in that instance, and thus we see that the word conduct and crime are used interchangeably. And of course, this could have been problematic for state parties, and they could have made this explicitly clear in, for instance, the Special Working Group on Aggression at the Assembly of State Parties. But in fact, in its 2009 report, it was stated that it was for this court to determine the meaning of Article 12.2a, and it is our submission to this court that in making this interpretation, you should interpret the word conduct to be the word crime. And we believe that this is supported by the Vienna Convention on the Law of Treaties, since the object and purpose of the statute and the contextual interpretation should be taken aside the ordinary meaning, and we should look to Article 31 to see that the object and purpose of the statute is prosecuting international crimes and preventing impunity, and it is not the prevention of all impunity that we're concerned with. What we're concerned with is we don't want to give a carte blanche to states to tailor their methods of warfare, to have long-distance delivery methods of warfare in order to escape criminal responsibility. And secondly, the contextual interpretation also supports this submission, since in Article 12.2a itself, for instance, when in reference to crimes committed on vessels, the word crime is used, and thus it would be an absurd interpretation to see that if a rocket is launched from a ship, the court would have jurisdiction, but if it's from another state, then the court would not. I will now take Your Honours to the third submission, and that
Excuse me, Counsel. If before you take us there, I wanted to ask you one quick question.
Yes,
we know this principle of in dubio pro reo, which means that if in doubt, then we have to interpret the statute to the benefit of the accused. Now, if I read conduct occurred, and I'm now sort of just surfing on the argument that we've heard before,
Yes, Your Honour.
it would sound to me that we're looking at the act as it was performed, as opposed to the effect, which would be what you called the crime, but which I would call the effect on the victim, right? Now, if I read this in context of the fact that I have to interpret the statute restrictively when it comes to my ability to prosecute, would that not lead me to saying that I have to take this to mean the act as opposed to the effect. Thank you.
I understand your concern, Your Honour. However, that specific provision of the Rome Statute that you're referring to refers to crimes, that crimes should be constructed strictly. However, here we're talking about a jurisdictional provision, which we believe is not a provision that is bound by the rule of legality. So, with regard to my submission in relation to war crimes, it is submitted that the IIW report satisfies the reasonable basis to proceed threshold, which is in the Kenya Article 15 decision was held to be the lowest threshold that we see. And at this stage, concrete and tangible proof is not necessary, since it is an early stage of the investigation, according to prosecutor in Bosco and Taganda case at paragraph 9. And the court is, excuse me, Your Honours, reminded that at this stage of the proceedings, the Office of the Prosecutor is somewhat limited in their investigative powers, according to the Situation in the Republic of Kenya Article 15 decision at paragraph 27. And the IIW report is a comprehensive report. It contains morgue records. It contains witness testimonies. It contains electronic data. It contains records of hospitals and morgues. And all of this information, we believe, satisfies this low threshold of reasonable basis to proceed. And in fact, any criticism of NGO reports, as there has been criticism of NGO reports, we accept this, has occurred at later stages of an investigation. For instance, this was in the backward confirmation of charges decision at paragraph 35. But here, we are satisfying a lower threshold. Thus, this report will suffice, in our humble opinion. And the DDS attack, we believe, in itself constitutes a war crime. And we believe that this occurred in the context of an international armed conflict. And according to the Lubanga judgment at paragraph 533, an international armed conflict is whenever there is resort to armed force between states. And in the Nicaragua decision, the court elaborated on what resort to armed force is. There is no definition of resort to armed force in the UN Charter, so we must look to the case law. And there, the court distinguishes a higher threshold of an armed attack, which would warrant recourse to self-defense, and a lower threshold of use of force. And we believe that we satisfy the higher threshold, therefore satisfying the lower threshold also. And there the court took the approach of scale and effects, meaning that we evaluate whether an armed attack is an armed attack based on the scale and effects or the consequences of such an attack. And the DDS attack does meet this higher threshold, since we believe that it is an act of violence according to Geneva Convention's additional protocol, Article 49. And the meaning of this protocol was elaborated by this court itself in the Taganda confirmation of charges decision at paragraph 46. And I quote, that there is no list of underlying acts of violence. What matters is the consequences of the act. And they found that in principle, I also quote, any conduct may constitute an act of violence. And in this instance, Your Honours, this is the conduct. This is the conduct that forms the act of violence that has initiated the international armed conflict. There is physical damage, Your Honours. That is the consequence. There is physical damage to civilian infrastructure, and there is damage to civilians themselves. There are 7,000 deaths. There is scarcity and contamination of water, food supplies, and needless deaths. And we believe that this forms the basis for an investigations into war crimes. At this stage, we cannot impute intention. At this stage, we do not have an accused, so we do not look into the specific elements of cyber attacks. But we do see a nexus between the cyber attack and the armed conflict, since it initiated the armed conflict, and there is temporal and geographical overlap between the conflict, and the cyber attack may constitute an act of willful killing, for instance. And if I...
Counsel, one
yes,
quick
sir.
question I had with one sentence. the consequences of the act, if I'm not mistaken, were power shortage and loss of communication, right?
Yes, Your Honor.
Now, these consequences, if one were to look at those, and if one were to accept that Additional Protocol 1 is usable in court here, would not necessarily lead us to think that this is a grave consequence, right? Loss of communication and loss of electricity. There's worse things in life. What do we make out of this? Thank you.
The submission is that you cannot separate those consequences from the consequences on civilians. Contamination of water supplies is directly related to the civilians who are at the receiving end of that water, at the receiving end of the plane crashing directly as a result of that loss of communication. And I will briefly summarize the final submission that a single victim's legal representative is sufficient. This is because a conflict of interest is not apparent under Rule 90, Paragraph 4, that we do not expect a conflict of interest to emerge in the future. And we see this in the previous determinations of this court, that if victims are united by their status as person targeted, as stated in the Muthuara VLR proposal at Annex 2, then they're united by their plight and will want to see this investigation put forward. Any allegations as to difference of opinion in relation to the polls or the annexation agreement, or indeed the plebiscite, are not determinative of whether victims want to see their family members' loss being avenged. And if I may ask for an additional minute, Your Honours, to conclude my submissions.
Please do.
Sorry?
If you can do it faster than that, please do, otherwise.
Of course, Your Honour. I would like to conclude on the following note. The purpose of this court at this stage, at Article 15 stage, is, according to the situation in the Ivory Coast decision at paragraph 21, is to prevent frivolous, unwarranted, and politically motivated decisions by the Office of the Prosecutor. This is not the case here. This is not frivolous, since there is nothing frivolous about 7,000 deaths and 3,000 injuries. There is nothing unwarranted about responding to an Article 12.3 declaration. And there is certainly no political motivation in wanting to investigate both parts of the conflict, be that from Astafa or Branos. I would ask this court to confirm the findings of the pretrial chamber 4, and that concludes my submissions. Thank you, Your Honour.
Thank you very much. Well, having heard both the government and the Office of the Prosecutor, the representative of the victims shall now please present its arguments to the chamber. Thank you. Yes.
Mr. President, Your Excellencies, may it please this honorable court. My name is Annabelle Teo, and I appear on behalf of the victims. On April 20th last year, Pantos was hit by a series of DDoS attacks which shut down all power and communications for 4 days. In that time, critical infrastructure and utilities such as water, transport, and electricity were disabled, leaving more than 7,000 civilians dead and an additional 3,000 injured. Despite this, Branos has refused to conduct any investigations or prosecutions into the matter. 234 victims, family members of the deceased, are therefore participating in today's proceedings in the hopes of securing a remedy for the losses they have suffered. To that end, the victims make the following 4 submissions. On issue A, that Astafa was competent to make its Article 12.3 declaration despite its loss of effective control over Pantos. On issue B, that this court has jurisdiction over acts committed over cyberspace pursuant to the objective territorial principle. On issue C, that there is a reasonable basis to believe that Branos' DDoS attacks constituted war crimes. And on issue D, that a single team of legal representatives is sufficient to represent all the victims. Now, as issue D is the one which most closely concerns the victims. With Your Excellency's leave, I would like to start by addressing it first. Thank you, Your Excellency. Now, the right of victims to come before this court and express their views and concerns is enshrined in various provisions of the Rome Statute. However, where there are many victims, this court may group victims together under a common legal representative pursuant to Rule 92, so as to ensure that fairness and efficiency are not unduly compromised. That much is not in dispute. The only question for this court is whether the victims here require two separate legal teams or just one. And according to the test stated in Katanga in 2009 at paragraph 12, this depends on both the similarities and the differences between the victims. We submit that a single team is adequate because first, the victims share substantial similarities, and second, the differences alleged by Branos are not material at the present stage of the proceedings. Now, counsel for the government has not disputed the substantial similarities in terms of language, location, the alleged crime, and the party who launched the DDoS attacks. However, they have argued for two teams for only two reasons. First, because some victims supported the plebiscite while others did not. And secondly, because some of the victims partially blame Estafa for the way the events have unfolded. However, these differences do not meet the threshold for separate representation. As stated in Katanga at paragraph 16, the test is whether the differences are so substantial that the representative will be receiving conflicting instructions that cannot be reconciled. In this case, no conflicting instructions will be received. We see that despite the differences, the victims are united in one common interest, that is, to find out the truth and to secure accountability and reparations for the tragic deaths of their family members. And to that end, they will instruct their legal counsel to support an investigation by arguing that this court's jurisdiction can be established.
Counsel, one quick question here. Are you so sure that these victims are so united? Because I hear from the submission from the government that, in fact, there is a high probability that the victims sort of point into two different directions as to the perpetrators of these crimes that they feel they are the victims of. Would that not make it the most blatant difference that you could have between victim groups?
Your Excellency, indeed, counsel for the government has argued that in this case, the victims might be pointing towards different perpetrators for the crime and has argued that this justifies separate representation. However, that is not true. If this court looks at paragraph 12 of the pretrial chamber's decision below, it is stated that the victims are not divided on who launched the DDoS attacks, but rather they have different feelings as to whether Estafa's actions might have contributed to the sequence of events which followed after that. They are not alleging that Estafa or any Estafarian official has committed a war crime. If we look at the feelings or the actions that they have stated a view on, that is, the fact that they did not acknowledge the plebiscite, and second, that they cleared the protests at Hugo Park. Neither of these actions would find a basis under this court's statute as a war crime. And therefore, the victims are not arguing that any perpetrator from Estafa should be apprehended and brought before this court. The only perpetrator they are seeking justice from in this case is the Bruneusen perpetrator, and in this regard, all the victims are united in their interest. We note that counsel for the government has further argued that in this case, the different political affiliations must be represented by different legal representatives. And they have relied on the Ruto case in 2011 in this regard. However, that reliance is misconceived. Political alignment is not invariably a ground for separate representation. In fact, as noted in the Ruto case itself at paragraph 4, the registry stated that it is only when political affiliations are central to the crimes alleged by the prosecutor. And the example given was if the attacks which caused harm to the victims were politically motivated in the first place. For example, they pledged allegiance to a certain leader and were attacked as a result of such support. But we see that in this case, regardless of whether the victims supported Branos or Estafer or voted in favor or against the plebiscite, they were all indiscriminately affected by the DDoS attacks. Your Excellency previously asked if the harm that they suffered as well as the remedy that they are seeking is the same. And because the same attack caused all the deaths which the victims are claiming accountability and reparations for, there is no division in terms of the victims of the remedy they are seeking before this court, and this difference on political affiliation is therefore not a ground for separate representation. Unless Your Excellencies have any further questions on this issue, I would like to turn to the remaining issues on the established agenda. Your Excellencies, I now turn to issue A. And on issue A, we do acknowledge that the relevant provision this court must look at is Article 12(2)(a) of the Rome Statute, where it is stated that a state can only make a declaration in respect of its own territory. So the critical issue for this court today is whether Pantos is still Estafer's territory. Now, unlike the prosecution, we are willing to accept counsel for the government's argument at its highest, that the date to assess competency is the date of the declaration. But nevertheless, Pantos remained Estafer's territory on the 25th of April. Counsel of the government has argued that the test for territory is sovereignty. But in this case, sovereignty requires continuing effective control. We submit that this is not the position at general international law. In fact, if this court has regard to the frontier dispute decided by the International Court of Justice in 1986, it was stated at paragraph 63 that when there is an established right of sovereignty, then the fact that another state is in effective control cannot detract from that position at law. And in this case, we note that Estafer was clearly vested with title over Pantos pursuant to a number of events. First, that prior federal borders deemed Pantos to be part of Estafer, and this was indeed confirmed in the 2005 dissolution agreement. Furthermore, Estafer was admitted into the United Nations on this basis, and even though if Mr. President is not minded to see this as confirmatory, there's a further evidence that is the borders were respected by both Branos and Estafer for 9 uncontested years. And therefore, there is no doubt that Estafer was clearly established as sovereign, and the loss of effective control after that could not change this. This case is distinguishable from the authority cited by counsel for the government, that is the Island of Palmer's case. Now, in the Island of Palmer's case, there was a dispute between the United States and Netherlands. The United States, because it had signed a treaty with Spain, who was purportedly the first discoverer of the island. Netherlands claimed sovereignty over the island because it exercised some administrative functions there and had some relationships with the local princes. But at no time was either the United States or the Netherlands established as sovereign, and therefore effective control was determinative in that case. This is not so here. There is a clear right of sovereignty, and this court does not have to have regard to effective control to determine the matter of competence. The only remaining point for this court, which I would like to address, is the Office of the Prosecutor's letter to Dr. Morsi's Article 12(3) declaration concerning Egypt. Now, there are two important distinguishing points between the present case and that letter. The first is that in that case, the Office of the Prosecutor was concerned with the question of government, who was the competent authority to represent the entire territory of Egypt. It was not concerned with questions of territory. And the second and more important distinguishing point is that in that case, the change of government was legitimate. And this was recognized by the United Nations General Assembly in a later meeting where the new government of Egypt was admitted, or at least was recognized as the proper authority to represent Egypt. And therefore, that letter cannot be taken as establishing a different test for competence as opposed to the correct test this court should apply according to international law. I'll now turn to the second issue of where the conduct in question here occurred. And now, in this regard, we note that counsel for the government has argued that the conduct in question here, that is the DDoS attacks, did not occur in Estafer or Pantos because it was launched from Branos. Now, we do not dispute that the attacks were launched from Branos, but what we dispute is whether conduct is completed the moment the attack is launched. Now, as Your Excellency noted previously, conduct can include both where the act originates from as well as where the act concludes. And in fact, this was the position taken in the preliminary examination of the shelling of Yongpyong Island. In that case, North Korea fired a long-range missile from its territory, which then hit one of the islands of South Korea. And the Office of the Prosecutor noted that the fact that it was a cross-border situation would not deprive this court of its territorial jurisdiction. In fact, both North Korea and South Korea would have territorial jurisdiction over the relevant launching of the missile, and therefore can delegate it to this court. Similarly, here we are concerned with a cyber attack which originated from Branos but ultimately terminated in Pantos, because the cyber infrastructure which was attacked were the systems supporting Pantos's power and communications grid. And therefore, since the conduct in fact did occur in the territory of Pantos, this court can authorize an investigation as the requirements in Article 12.2a have been satisfied. Now, we do note, however, that Your Excellency has expressed a concern about...
Excuse me, Counsel.
Yes,
One
yes.
quick question on your definition on conduct. As you may know, in Article 30 of the statute, we make a difference between conduct and consequence. If one were to follow that, we would be looking at conduct as the act, and maybe then consequence as the effect of what has happened. Does then Article 30 and its wording not contradict your current submission? Thanks.
Your Excellency, Article 30 does not contradict our argument. Now, here, we are not contesting or we are not attempting to conflate the distinction between conduct and consequence. Our argument is that conduct properly includes both the launching of the attack as well as the receipt of the attack. And because this receipt did occur in Pantos, this is sufficient for this court to establish territorial jurisdiction. But Your Excellency has expressed a concern previously that in this case, penal statutes need to be strictly construed. However, we submit that this principle of strict construction would not be a bar for this court's jurisdiction. Now, we note here that in this case, the crimes being alleged are the direct attack on a civilian object, as well as attacking or directing an attack which causes disproportionate civilian harm. Now, in both these crimes, there is no specific instrument or weapon which must be used. And therefore, essentially, the perpetrator has discovered a new means of committing an existing crime. And this does not amount to an extension of this statute, which would be prohibited by either Article 22.2 of this statute or any general prohibition of extending crimes beyond what they were originally understood as covering. Now, I'll briefly turn to my final submission concerning issue C. Now, on this point, we note that there are two fundamental principles in any military operation which must be respected. First, civilians and civilian objects may never be targeted under any circumstances. And this is known as the principle of distinction. The second cardinal rule is that even when targeting a military objective, the incidental civilian harm cannot be disproportionate. And this is the principle of proportionality. Now, we submit that Branos has violated either of these principles and has committed a crime under Article 8.2b2 and Article 8.2b4 of the Rome Statute. Now, counsel for the government has disputed one common element between these two crimes, and that is the existence of an international armed conflict. Now, our primary position is that there was an international armed conflict in this case because the ground assault carried out by the Pantosian Liberation Army can be attributed to Branos. Now we note that counsel for the government has not disputed the correct test to apply for attribution. That is found in the Tadish judgment, which was affirmed by this court in the Lubanga case. However, she has argued that in this case, there is no direct evidence of planning, coordination, or cooperation between Branos and the Pantusan Liberation Army. That is not true. This court looks at the pretrial chamber's decision at paragraph 10. It is stated that DDoS attacks and the ground assault were well coordinated. That is quoted from the judgment itself. And this well coordination was evidenced in the way that the Pantusan Liberation Army was mobilized within a few hours, even though power and communications were already shut off. And therefore, there was a lot of discussion and planning and coordination between Branos and the PLA for this to be achieved. And very significantly, it must be noted that on the very day that the PLA took control of Pantos, it immediately allowed Branos to annex the territory. And therefore, there was a close relationship between these two parties, sufficient for this court to find that the internal armed conflict created by the ground assault could be internationalized. Now turn to Your Excellency's concerns that in this case...
One quick question here, but we do agree that on the facts of the case, as to what we know, we're looking at a threshold that is underneath overall control or not?
No, Your Excellency. The test to be applied still remains the overall control test. However, the standard of proof which the prosecution is saddled with at this stage is one of a reasonable basis to believe. And we submit that the evidence, as stated in the pretrial chamber, can establish or can satisfy the overall control test at the relevant standard that the prosecution has to. Now, we do note, however, that Your Excellency was concerned with the question whether the attacks in this case, which merely disabled and temporarily disabled communications and power in Pantos, would constitute or would rise to the level of an attack, given that no physical destruction of the computer systems occurred. Now, we submit that an attack has to be looked at in terms of its consequences and not just its pure form. And according to the prosecutor and Takanda case in 2014 at paragraph 46, the consequences must be assessed according to what injury, death, or destruction was intended or foreseeable consequences. And a 4-day deprivation of electricity and communications would definitely have been expected to cause widespread death and destruction of civilians as well as civilian objects. So we submit that for all the elements contested by counsel for the government, these elements have been satisfied and therefore has established a basis for the war crimes. Ultimately, this court has the jurisdiction to authorize an investigation in this case, and that a single team of legal representatives is sufficient to represent the victims. Unless I may be of any further assistance to this court, this concludes my submissions. Thank you.
Thank you. Well, I believe that very important points have been raised in the statements made by each of the parties and participants. So now each party will be given, in the same order, the possibility to reply to the points made by the other parties. It's important to respect the time allocated for this exercise. No team will be given more than 10 minutes for their rebuttal, and I would ask Government Counsel now, please, to proceed.
Distinguished members of the court, before I begin my rebuttal, I would like to mention that there is a need of sufficient information for a reasonable basis to proceed to initiate an investigation. Beginning with my rebuttals in my first submission, the prosecutor mentioned the case of Palestine, where it was UN recognized. In the present matter, Branos does exist as a state and is a UN recognized state. Further, Your Honor, they referred to the case of Bagbo, in which the region of Congo was under the effective control of the state of Uganda. I would like to bring to your notice that Uganda is a state party to the Rome Statute and does not apply in the present matter. referring to the case of Island of Palmas that the Victims' Council brought up and said it should not be applied in the present case. Your Honors, the most recent judgment, the most recent report regarding effective control is the situation in Egypt, where it specifically states that effective control is required, and it is a de facto decision where the obedience of the bulk of the population is absent. And it's clearly stated that on the 24th of April 2014, the entire region of Pantos was not under the control of Astafurian government. The facts are very clear on this aspect of effective control of that region. Therefore, Your Honors, effective control did not exist, and Astafur is not competent to make a declaration before the court. Moving on to my rebuttals in my second submission, the Office of the Prosecutor brought about the case of al-Bashir and said conduct was equated to crime. Your Honor, there is a clear distinction between a state party to the Rome Statute and a declaring state before it. That was the case of a state party to the Rome Statute, which was an internal matter, and there was no requirement of separating conduct and effect. But in the present case, as it is a cross-border crime, there must be a distinction made. Further, Your Honors, there must be a strict interpretation of conduct that should be made. The Victims' Council refer to the Korean case where the situation was rejected by the pretrial chamber and therefore cannot be relied on. Moving on to my rebuttals in the third submission, Your Honor. In the situation in Kenya, the pretrial chamber asked the Office of the Prosecutor to bring more sufficient information before the court, even when they had numerous NGO reports before them. In the present matter, it is only a matter of one NGO report, and there is a requirement for the Office of the Prosecutor to provide more additional information to fulfill the evidentiary standard of sufficient information for reasonable basis to proceed. Further, in the case of situation in Korea, it was rejected as the subject matter jurisdiction was not proved. The specific elements alleged must be proved for the court to initiate investigation in a matter. This has not been done by the Office of the Prosecutor. The Victims' Council did state that the principle of distinction and principle of proportionality have been violated in the present matter. Your Honor, for the principle of distinction, it should be an intentional attack against civilians and civilian objects. The wording additionally in the IRW report in paragraph 10 of the fact sheet clearly suggests that was not the intention of the attack. Further, the principle of proportionality requires a clearly excessive amount of collateral damage to the civilians, which is not present in this case, Your Honor. And therefore, the specific elements of war crime have not been fulfilled.
One quick question here, or rather two. If you could very quickly elucidate me on, if I look at the case, I see that the attacks on the communication system and the electricity, both civilian systems, if you want, was intentional. So I would want to hear how you see that this was not a directly intended attack, number one. And number two, with regard to the proportionality, I recall 7,000 civilian victims. How does that sit with your submission that it is not excessive? Thank you.
Your Honor, to answer your first question, the reason the electrical and communication grid was attacked was not because it was a civilian object, but the intention that it would lead to a military advantage. And therefore, it is not directing against those grids as a civilian object or with the intention of affecting civilians. Further, to answer your second question on the principle of proportionality, I understand, Your Honors, that 7,000 victims suffered. I empathize with them. However, it is not sufficient here to prove, there is not sufficient information to prove that the principle of proportionality was not upheld. As in case of principle of proportionality, if there is a military advantage higher than that of collateral damage, and if the collateral damage is not clearly excessive, then it cannot violate the principle of proportionality. It is a very high threshold that is required, and the information present before the court is not suggestive of this threshold that will violate the principle of proportionality. In view of this, I pray before the court that the office of the prosecutor must provide additional information to first prove the reasonable basis to proceed requirement to initiate an investigation. Further, to rebut the points of the fourth submission as given by the victim counsel, they clearly stated that in the case of prosecutor versus Ruto, the political alignment must be central to the crime that has occurred. In the present matter, the war crime occurred in relation to the secession that the people of Panthos wanted. By not allowing separate legal representation, new and relevant facts and circumstances that can be brought before the court will not be available if not for this separate legal representation. Therefore, this political alignment is central to the issue of the war crime. If not for the wishes of the people to secede from that of Astafur, there would be no war crime today, Your Honor, as alleged by the victim's counsel. Therefore, in view of this, the court should not authorize an investigation in the situation in Astafur. If Your Honors have no further question, I would like to rest my case.
Thank you. I now turn to the prosecution to make its final observations. Thank you.
Your Honours, I will be making 4 points of rebuttal for you today. Your Honours, my colleagues appear to be jumping the gun. Branos is invoking the right of defense, and the victim's legal representative is considering mental elements of crimes already at this stage. Whilst we respectfully take note of these submissions, we will consider these issues at a later stage with full independence in delivering to move ahead or not move ahead after an investigation has occurred. In light of this, we submit the following points of rebuttal. Firstly, on the first issue of an Article 12.3 declaration, my learned colleague from the Council of Branos has stated that Uganda is not a state party, but as the prosecution has also submitted in Ivory Coast, or rather Uganda is a state party, Ivory Coast isn't a state party, and this was an Article 12.3 declaration, and nevertheless the lack of territorial control was not a bar to this court exercising jurisdiction. The Egypt test cited by my fellow colleague in Branos also seems to support our conclusion that the UN recognition is key to this court's understanding of effective governance. And thirdly, Branos has stated that Branos was recognized by the UN, but the UN did not recognize the borders of Branos to have included Pantos when it was recognizing Branos. Indeed, the dissolution agreement, the Velvet Divorce Agreement, distinguished determining the prior federal borders, Your Honours. I will now move to my second submission, that the word conduct includes the word crime. And we're unsure whether, firstly, the Victims' Council suggested that conduct includes the effects of what had occurred. We recognize that there is a distinction in terms of wording. We see it in paragraph 7a of the introduction to the elements of crimes. We see that the conduct, consequences, and circumstances are distinguished in the statute in that way. However, we say that conduct is interchangeable with crime, noting that the court has already done this on several occasions. We're not creating a legal fiction here. We're just merely using the interpretive tools of the Vienna Convention of the Law of the Treaties and looking to the practice of this court to that effect. And thirdly...
One quick question for my understanding. Would we as the court be bound by previous decisions that, say, pre-trial or trial chambers have made to this effect? Thank you.
No, Your Honour. However, the court may take these decisions into account according to Article 21 of the Rome Statute. Also, what has been raised by the Council for Branos is that the al-Bashir decision was not a trans-border situation. However, we recognize that this is a new situation. We recognize that this hasn't come before this court, and we put our trust in this court in taking the interpretation that has been suggested by our office in this instance, and recognize that this court has used the two words interchangeably, and perhaps this is indicative of what should be, how this provision should be interpreted in the future. And in relation to breach of principles of law, this issue raised by Branos that this would be a breach of creating obligations to non-party states. Well, we believe that exercise of jurisdiction does not create any obligations. Indeed, Branos is not obligated to cooperate. However, the cooperation did actually occur since when the IIW staff went into Pantos. This was acquiesced by the Pantosian people. Therefore, that may indicate some cooperation. And now, if I may move on to the third submission, that Astafa is, or rather that Branos may have been responsible for war crimes in the region of Pantos. The Council for Branos has stated that we cannot rely on one NGO report. And we then asked the Council for Branos, well, how many reports do we need? How much evidence do they feel that we need? Because in the understanding of this office, evidence is evaluated on a case-by-case basis. And indeed, in the Benba confirmation of charges decision at paragraph 49, it was stated that a single piece of evidence can be relied on in launching an investigation. And furthermore, the Benba confirmation of charges decision did state something that my colleague from Branos has relied on regarding the probative value of NGO reports. But the full quote that we would like to suggest at paragraph 51 is that, as a general rule, a lower probative value will be attached to indirect evidence. We accept this. However, the Chamber does not disregard it, and in that case, the Chamber did not disregard this evidence. And therefore, at this lower stage of the investigation, we feel that it is sufficient to satisfy the threshold of reasonable basis to proceed. And with regard to the last point on this issue, Council for Branos has stated that the military advantage here was proportionate to the victims suffered. But another question that we posed to them is, well, why not just attack Camp Astaf? Why not exclude those 7,000 civilians that were to the north of Camp Astaf and just target the actual military camp? That would have been a clear military advantage. So we feel that this principle was not satisfied by Branos.
Counsel, one quick question there. If it is my target to exactly sort of paralyze the country by paralyzing its communication and electricity structure, if that is my military target, my military strategy, would this not rather than mitigate in favor of using a cyber attack, because no armed force and no physical destruction is being used, but rather a simple coding? Thank you.
Yes, Your Honor. Perhaps it is a very effective strategy. However, it would also then completely violate the principle of distinction, since there is no distinction between civilians and military in that instance. So with regard to the final issue, that of splitting or keeping the victims together, we remind the court that victims have not asked to be split, and there is indeed no need to split them at this stage of the investigation. And the Council for Branos has submitted that political alignment of the victims is determinative of their distinct interests, citing the Ruto and Sang common legal representation decision. However, we should point out to this court that at paragraph 7, nowhere in this decision is there a discussion of political alignment. And in fact, where this does come up is the summary of information on the grouping of victims document of the registry Annex 2. And there it says that the case is framed in terms of political alignment, with ethnicity being presumptive, not determinative of the latter. And thus, although we may take this political alignment into consideration, the political alignment that we have seen as a result of the plebiscite was before this attack occurred. And we think that it is an entirely reasonable conclusion that the family members whose loved ones have been killed or injured severely by these events would not want to any longer join the country that is potentially responsible for these events. I would like to conclude on the note that in asking to confirm the pretrial chamber decision, we're asking the court to rise to the challenges that new methods of warfare present and look to the future in interpreting the jurisdictional provisions of this court. That concludes my submissions. We submit that the pretrial chamber 6 decision should be confirmed. Thank you for your attention, Your Honours.
Thank you. And now the last word is to the legal representative of victims, and you now have the floor.
Mr. President, Your Excellencies, 4 points to make in rebuttal. First, concerning counsel for the government's suggestion that it is unsafe for this court to look at the example of the shelling of Yongpyong Island as evidence that conduct can both be considered where the act starts and where the act ends. Now, counsel for the government has stated that in that case, no investigation was authorized. We agree. That was the case. But what counsel for the government has failed to do is explain why this conclusion was reached. Now, in that case, the Office of the Prosecutor ultimately refused to open an investigation because there was insufficient evidence that the acts were of the gravity of war crimes, not because the Office of the Prosecutor doubted that an attack, or rather conduct, can occur partly in one state and partly in another. And therefore, this is not a ground for this court to dismiss the shelling of the Yongpyong Island as evidence that conduct includes both where the act starts and where the act ends. Turning to the second point of rebuttal. This concerns counsel for the government's argument that in this case, this court is only relying on one piece of evidence, that is the International Rights Watch report. Now, this is not the sole piece of evidence being relied on to establish this court's jurisdiction. Most of the facts which both the prosecution and the victims rely on are actually set out in paragraphs 1 to 9 of the pretrial chamber's decision below. And these facts were stipulated by parties to the chamber itself. The only additional information which the IRW report provides is the cyber signature linking the DDoS attacks to Branos. But even on this point, the cyber signature, or the fact that it can be attributed to Branos, is corroborated by the circumstances of the DDoS attacks. Now, in this case, the DDoS attacks were launched for the specific purpose of assisting the Pantosian Liberation Army to carry out its ground assault, so that control could be taken over Pantos and then the territory could be annexed to Branos. Now, we see that the DDoS attack played a crucial role in securing this purpose. And given that Branos was the beneficiary of the entire military operation, it would in all likelihood have been a Branosian perpetrator which launched the DDoS attacks. So this court is not relying on just one piece of evidence. Rather, it is simply taking a realistic view of the facts which the pretrial chamber has already provided to us.
Counsel, one quick question here. The fact that it benefited the Brano government, or the sort of Brano, would that in and of itself lead us as circumstantial evidence to believe that they are behind an attack, only because it benefited them in the end?
Your Excellency, our position is that because the entire military operation was for the objective to allow Branos to annex Pantos, and therefore all these acts which led eventually to the securing of that objective would in all likelihood have been committed by Branos. And in any case, this is sufficient to provide a reasonable basis to believe that the attacks in this case were actually committed by Branos. This is the lowest evidentiary standard which this court will apply at the authorization stage, and the prosecution does not have to eliminate all other possibilities which can coexist with such a conclusion. I'll turn now to the third point of rebuttal, and that concerns the fact that in this case, counsel for the government has argued that there is no clear evidence that the foreseeable incidental harm to the civilians were excessive. Now, as the ICRC commentaries to the additional protocols state at paragraph 2212, various factors must be considered in determining what is a foreseeable danger to civilians. This includes, for example, the weather conditions. Now, in this case, the prevailing weather conditions in Pantos were very harsh. Pantos is an arid region. This is set out in paragraph 10. And an arid region is one where there is a severe lack of water and where there's insufficient water to even support the growth of vegetation. Now, it was expected then to the perpetrator that any prolonged deprivation of power and communications would hinder the supply and availability of both food and water, and this would result in many deaths. Furthermore, in this case, it is common knowledge that a city's power grid supports critical installations such as life support equipment, hospital services, and emergency services. And because of the shutdown of electricity, many deaths resulted from things like the loss of life support equipment, as well as neonatal care, which are critical for vulnerable portions of the population, patients in the hospitals, for example. And furthermore, people who were injured because of accidents in the dark could not have access to medical services because lines of communication to emergency services were not operating at that time. So it was entirely foreseeable that an entire shutdown of power and communications in a region would result in widespread deaths and destruction. And counsel for the government is therefore cannot therefore argue that this was not foreseeable. Now yes,
Counsel, you say foreseeable. Which crime are you looking at when you say foreseeable? Because I read, for instance, for the attack against civilians, that it has to be intentional. Thank you.
Apologies, Your Excellency, if I wasn't clear on this point. When I mentioned foreseeable, this was in relation to Article 8.2b.4. The attack that causes disproportionate harm. But if Your Excellency is concerned about the intention element for the crime of attacking civilian objects, we submit that the past practice of this court has been to dispense with the mental element at the stage of an authorization. This is both found in the cases of the situation in Kenya at paragraph 79, as well as the situation in Ivory Coast at paragraph 29. And this is because at the authorization stage, there is no accused presently before this court, and therefore mental elements such as intention and knowledge cannot be adequately addressed at this stage. Therefore, it does not have to be proven determinatively at this very point. Now turn to the final point of rebuttal concerning victims' representation. Counsel for the government has argued that in this case, the war crimes, the DDoS attacks, occurred in relation to a political disagreement created by the plebiscite. However, this political disagreement merely forms the background to the DDoS attacks itself. She has not shown how the political affiliations have changed the way victims suffered harm or have changed the remedy that the victims are seeking before this court. Furthermore, she has argued that the different political views might present new or different perspectives for this court and therefore requires separate legal representation. However, as this court held in the Banda decision in 2012 at paragraph 33, even though certain Darfuri victims wished to present additional information to the court in light of their local ties to the community, they wished to broaden the factual circumstances of a case, the court held that it could be achieved even within the framework of a common legal representative. Therefore, as Victims' Counsel, we are able to present to this court all the divergent views of the victims concerning their views on the plebiscite, concerning their views on the partial blameworthiness of Estefa, without the victims actually having to be separately represented. If it is a matter of new facts or additional facts which this court wants to hear, then the Victims' Counsel can do it and can express differences in views which will not result in conflicting instructions. Unless Your Excellencies have any further questions on any of the issues, this concludes my submissions. Thank you very much.
All the arguments now having been heard, the bench will now leave the courtroom to proceed with deliberations. Participants may leave the courtroom, but will need to be present here again at 11:45. Thank you.
All rise. All rise. The International Criminal Court Moot Court Competition 2015 English edition is now in session. Please be seated.
Well, the first thing to say is that this has been far from easy. According to the rules of the ICC Moot Court competition, deliberations were made to assess each of the teams participating based on the following criteria: knowledge of facts and legal principles, articulate analysis of the issues, the use of authorities and citations, ingenuity and clarity, persuasiveness, logic and reasoning, and finally, presentation. We're going to make short comments about each of the teams, and with regard to the government's team, I would ask my colleague, Savina Savides, to say a few words.
Thank you, Mr. President. So I would like to say, for the government team, I noticed we noticed a very solid presentation of the case. I would have to say impressive advocacy skills by pleading without notes. That is a point to underline. Also very responsive, and also the answers given on the points were prepared, composed. Also very articulated arguments. And also overall a good, that shows a good organization, a good, also been in a good preparation for the case and knowing your facts and also the legal arguments on that. Thank you.
Thank you. We now turn to the prosecution team. I would ask my colleague, Mr. Philip Hambach, to say a few words.
Yeah, dear prosecution team, I can only say so much. It was really very well structured. I really liked the way how you guided the judges through the submissions that you made. You had obviously also a difficult case to argue. That is also a big point. We particularly appreciated also your responsiveness to the questions. I enjoyed to be shut down by the in dubio pro reo point. I think also the argument on armed force, additional protocol, that really was sound, well structured. So we were really appreciative of the way that you presented this. In particular, the rebuttal. We noted that you use the rebuttal for what it is to be used for, and that is really coming back on the arguments that you're getting from the opposing side. And we found that persuasive and really in the spirit of what the rebuttal is made for. So a very, very, very solid performance. Excellent. Thank you.
Thank you. And in respect of the victims' representatives, it was clearly very well prepared, excellent grasp of the facts and the law. Thought the advocacy was very able, and that the advocate didn't fluster under questioning, which is always difficult and important when presenting a case to any court. Intellectually sound arguments and realistic assessments of fact and law. It was well structured. Of course, simply to get to the finals of the ICC moot competition is a great achievement. One could liken it to the Olympic stadium, where at the end of any particular event, 3 people all get onto the rostrum to receive the gold, the silver, and the bronze medals. But simply to have got to the Olympics is a great achievement. To stand on the rostrum at the end is a fantastic achievement, whichever position one is in. I now give the floor to my colleague Sabina Savides, who will announce the second runner-up.
So the second runner-up for the ICC Moot Court Competition 2015, the English edition, is the government team.
I now give the floor to my colleague, Mr. Ambach, who will deal with the first runner-up.
Now, the first runner-up in 2015's moot court competition on the ICC is the, where was it? Prosecution team.
I don't think that what I'm going to say now is going to come as a great surprise to those of you versed in deductive logic. The winner of the ICC moot competition in 2015 is the victims team. Now, this was an extraordinarily close decision, I have to say. It was, in the end, by a majority decision between the judges, and there was but 1 percentage point between the first and second place. It doesn't get any closer than that. But as I say, to reach the finals of this competition, which is the premier international criminal law mooting competition in the world, is a very, very significant achievement. And I'd like to congratulate all participants in this high-level competition. I know, because I mooted myself at university and at bar school, how much work you have to put in. More than that, I know that how much dedication those who support and coach the teams have to put in, many hours of hard work and dedication. And the result of that has been an extraordinarily high standard of advocacy. There aren't any of the advocates here who don't match many of the professional advocates who have appeared in front of me over the years, and some of you are distinctly better. I leave it at that. Thank you all, very well done. But we now turn to the presentation of the prize to the best overall oralist. Again, that was a very close run thing, but I'm pleased to announce that the best overall oralist is Annabelle Teo. What makes it even more special is that people are working often in a second or third language. That is really impressive. It's particularly impressive to an English person because, as you know, in the UK, our language skills are notoriously poor, apart from English. Thank you very much indeed. I welcome you all now to a reception in the public area of the courtroom. The ICC protocol staff is ready to escort you to that area where we will meet again. And I congratulate you all again for your excellent work and deep knowledge of the ICC and Rome Statute system. Without young people coming into the fold, the court and the international law cannot improve and progress. And that's something which simply must happen. The moot court appeals hearing regarding the situation in Astafur is now closed.
All rise.